Well, that's not an easy thing to do. Hmm. I don't know. Ah, okay. Here comes everybody. You folks hear me at home? Give me a thumbs up if you can.
Yes.
Great, thank you. Sorry about the mix-up on the title of the class. What happens is you start typing them in on the Twin invite, on the Twin email, and it pulls up one that you've sent recently. And so I just sort of assumed that it was what I was working on. All right, today we start with this topic called limits on state regulatory and taxing power. Just to sort of explain where we're going with this, I have just a little sum up here. We will do preemption today. We will start the so-called dormant commerce clause today. We will not finish the dormant commerce clause today. We'll finish that up on Thursday. And then on Thursday, we'll fairly quickly do privileges and immunities and move on from there, okay? So we're close to about halfway done with the semester. It's been a different one, I can tell you that. So just a quick discussion here of what we're talking about when we talk about limits on state power and how these three things limit state power. The first is preemption, and this comes up quite a bit. It's tested fairly heavily on the bar exam, and it comes up quite a bit in the real world. It's one of those con law concepts that you will be using if you do litigation, if you do any form of civil litigation in the future. And essentially, it's based off of the supremacy clause. And if there's a conflict between state law and federal law, as we know already, the federal law is deemed supreme, and so the state law will be preempted. I wish it were as simple as that. It's not. It's a bunch of rules that go with it that we'll talk about. And what I'll do with preemption is I'm going to give you the rules in advance so that as we go through the cases, we can sort of discuss how the rules unfold. I wish I hadn't worn a sweater today. It's a million degrees in this classroom. We took this classroom because it's supposed to be cooler than the one on the other side of the building. We'll then get into the dormant commerce clause. Now, we've talked about the commerce clause, and we know for a fact that the commerce power resides in Congress. Congress has the right to pass laws affecting foreign commerce, interstate commerce, and commerce with the Indian nations. And whenever you have a commerce clause question, you're going to see a statute that's a federal statute, and the question is going to be that did Congress have authority to enact that law under the commerce clause, okay? This is going to be a little different. This involves the negative implications of the commerce clause. You're never going to have an act of Congress. What you're going to have instead is an act that a state passes. And the claim is going to be that even though Congress has not regulated in this area under the Commerce Clause, this state law interferes with interstate commerce. And it's almost always because it discriminates against out-of-staters, protectionism for in-state businesses, and the like. And very close to that will be the Privileges and Immunities Clause under Article 4, We're going to talk about privileges and immunities twice this semester. This will be the first time we're doing it, so-called Article 4 privileges and immunities. Later on, we'll be dealing, there's a privileges and immunities clause under the 14th Amendment that we'll be talking about as well, okay? And privileges and immunities is a concept coming straight out of the Articles of Confederation, where states would discriminate against out-of-state businesses and out-of-state people. And the whole idea of the Privileges and Immunities Clause is that I should be able to go anywhere in the United States as a citizen of the United States. I should be able to go anywhere in the United States and be treated as if I had grown up and lived in that state for my whole life. Get all the same privileges that an in-state person gets, get all the same immunities that an in-state person gets, okay? So these last two, the Dormant Commerce Clause and the Privileges and Immunities Clause, will deal with discrimination against out-of-staters. That's the basic nub of what those topics are getting into. So we'll start first with preemption. I'll start with the boring part of it, which is, you know, the methodology of how to go through it. Here is the Supremacy Clause. Notice once again what we consider to be federal law. Federal law is this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And it binds state judges as well, okay? So, you know, we'll talk a little bit later on about the full faith and credit clause that kind of goes with it, where you respect other states' decisions as well. But here, if there's a conflict between a state law and a federal law, whether it's the Constitution, an act of Congress, regulations promulgated under an act of Congress, or a treaty, the state law must yield, and the state law will be preempted, okay? And this also will happen, as we'll see, in some common law state tort cases. So I'll give you a question later on in the class. If there's a federal regulation that prescribes safety standards, and someone claims that despite the fact that that existed, and you know the federal safety standard was followed, if you claim that the implementation of it was still negligent, it will likely be preempted, and we'll talk about that later on. Students tend to struggle with that a little bit, but we'll hopefully try to clear that up. Now, the only time that we're going to have a supremacy clause issue where the federal law is being called supreme is when there's a conflict between a valid federal law and a valid state law, okay? If there's no conflict, if there's just overlap, but there's no conflict, you don't call on the supremacy clause and you don't even consider the issue of preemption. It's when there's a claimed conflict that we get into the whole question of preemption. And I think we've seen already there's a fair amount of overlap between federal areas of regulation and state areas of regulation as well. You can have the government, the federal government, be able under the Commerce Clause to regulate an area, and have the state also able to regulate that area under its police powers, under its 10th Amendment police powers. All right, here's the methodology that we're gonna follow. And this first slide is really less about methodology and more about how to spot a preemption issue. How do you know if there's a preemption issue? And what you're going to need is both a federal law and a state law in the fact pattern, okay? Both a federal law and a state law in the fact pattern. Now, you recall when we talked Commerce Clause, the authority under the Commerce Clause, there was only a federal law at issue. Here, the question is going to be, must the state law yield to the federal law? That's always what you're getting back into when you get into preemption. So in order to see whether there's a conflict, the fact pattern is going to have to identify some federal law, a statute, a law, a regulation, the Constitution, a treaty, some type of federal law that's at issue. And then you're going to need a state law that's at issue. Most of the time, it's going to be a state statute, a piece of legislation. But as I've mentioned already, it could be a litigation under a common law cause of action, a state common law cause of action as well. So, you know, for example, negligence in most states is not derived from a statute. The elements of negligence are derived from common law, and you guys have learned the elements of negligence already, okay? But those, you know, will vary a little bit from state to state, and that's what we're talking about when we talk about state common law. Before you, again, a sort of a precursor to getting into, if you've identified there's a potential preemption issue, before you get into it, look for a better way out. And the better way out is, well, wait a second, maybe Congress didn't have the authority under the Commerce Clause, or under the taxing power, or under the spending power. Maybe Congress didn't have the authority to enact that law. And so I'm going to challenge it on the lack of authority first before I get into my preemption argument, okay? And again, we've talked about the enumerated powers and what Congress has to act under, mostly the Commerce Clause. We talked about the Taxing and Spending Authority. We talked about Section 5 of the 14th Amendment, which has been very narrowly construed by the courts. So if there are decisions saying no authority, then don't even get into preemption. We're going to see that there's two general types of preemption. The first is called express preemption, and the second is called implied preemption. There are subcategories of implied preemption, okay? So we're going to talk about, you know, under implied preemption, we're going to talk about field preemption, and then we're going to talk about conflict preemption. And don't worry, slides are coming right up on this in just a second, okay? And then there's two subcategories of conflict preemption, which I call impossibility preemption and frustration preemption, okay? So the first is express preemption. This is where, so the easiest example of this is that Congress passes a law and it says right in the law, this law is intended to preempt all conflicting state law. Here you have Congress, you know, intending to occupy this area of the law exclusively, and saying so right in the statute. That's why it's obviously called express preemption. You would think this would be easy, but it's not, okay? It's not, because sometimes you have to figure out what was the scope of the law as Congress intended it. And so people who are trying to avoid the express preemption will say, well, wait a second, what you're trying to preempt here is different in scope than what Congress is trying to do. And we'll see through a couple of examples in our cases how that works. And unfortunately, it can get murky at times. Actually, I had forgotten that I have an issue here. Tobacco is often involved. The tobacco industry is often involved in preemption cases. And so in this good case, what we're going to see is that there is a federal, there's a series of federal laws regulating how tobacco products can be advertised. And trying to prevent false advertising and trying to ensure that proper warnings about the dangers of tobacco are made available to people who might consume the products. As we'll see later on, Congress has decided it wants essentially a uniform law. It wants to occupy the entire field under a uniform law rather than having 50 different laws from state to state. So Maine decides that it's going to sort of supplement it, it does so under its Maine Unfair Trade Practices Act, which sounds to me, I'm not licensed to practice in Maine, but it sounds to me to be quite similar to the Massachusetts Consumer Protection Act, which we call Chapter 93A in Massachusetts. Here, right in this Cigarette Labeling and Advertising Act, the federal act, Congress says no requirement of prohibition based on smoking and health shall be imposed under state law with respect to the advertising or promotion of any cigarettes, the packages of which are labeled in conformity with the provisions of this chapter. So Maine goes and it passes a law that deals with this type of thing. And what Maine says and what the court buys is that we're not talking about health, we're talking about deception under this Maine Trade Practices Act. And Congress did not intend to replace all the state anti-deception acts or consumer protection acts, okay? So this is essentially an argument that it's outside the scope of what Congress was trying to cover. That works sometimes and it doesn't work other times. And once again, this comes down to judicial philosophy. Judges who tend to be conservative, with a small c, once again, warning you, there's a difference between judicial conservatism and political conservatism. There's overlap between them, but they don't always run the same. Judges who we would call conservative tend to like federal preemption more than judges we tend to believe are liberal. They basically want to allow these types of lawsuits to go forward under state law. The liberal justices and the conservative ones, if Congress has legislated on the area, are more likely to find that there is preemption. That's express preemption. Under the types of implied preemption, the first is called field preemption. And with field preemption, you don't have express preemption. If you have express preemption, you're done. You don't have to go any further, okay? I'm talking in the practice of law, not necessarily of what you would do on an exam. You'd keep going on an essay and telling me that even if the court finds there is no express preemption, we have to consider whether there's field preemption, okay? Now, in field preemption, these are hard to give you fact patterns on in the bar exam, okay? You have no express preemption, but after reading the law of Congress, and sometimes these laws are very extensive, and they're often supported by regulations that have been promulgated by federal agencies. But after reading the federal law, you see what's the words we use? A scheme of federal regulation so pervasive that Congress must have intended to occupy the entire field. So you're usually looking at long, complicated, detailed laws that make it clear that Congress was trying to, take over the entire area, occupy the entire field. And if you can say that, you can find field preemption. And so I give you an example of this old case, the Rice versus Santa Fe Grain Elevator Corporation case back from 1947. I hadn't realized it, but apparently there is a whole pervasive scheme of federal regulations regarding warehousing grains and other agricultural products. And so the state of Illinois has this grain warehousing law, and they prosecute someone for violating it. And the person who's prosecuted says, probably the Santa Fe Grain Elevator Corporation says, no, this is preempted because there's all these federal regulations out there on this area, and they are so pervasive, so extensive, that the only reasonable conclusion is that Congress intended to occupy the entire field, okay? And so the reason why it's so hard to give you one of these is because neither I nor the bar examiners are going to give you a federal law that's 500 pages long and that shows an extensive entry into the field. So they're going to have to tell you in the fact pattern, give you clue words, you know, like a long statute, very detailed, very involved. You know, Congress has been interested in this area for forever. By the way, I do know that grain storage is a federally highly regulated field area. When you store grain in a silo, it creates this very fine grain dust that's both unhealthy for people to breathe and also is highly ignitable. It hasn't happened for a long time, probably because of federal regulations. But we used to see in the news occasionally these huge explosions of grain silos because something, you know, sparked the fine airborne grain particles and then caused the whole thing to go up and explode. So it is a highly regulated area, okay? So once again, if you find field preemption, you're done. You don't have to go further. So first, try to do express. If there's express, you're done. Second, if there's no express in this field, you're done. But if there's no express and no field, now you have to go on to the so-called conflict preemption. And again, this takes one of two words. I called, well, the first one is impossibility, which is easy. The second one is actually obstacle. I called it frustration, but it's the same thing, essentially. So impossibility preemption is easy to figure out because it's literally impossible to comply with both the federal law and the state law. So the federal law doesn't expressly preempt. The federal law doesn't purport to occupy the entire field, so there's no field preemption. However, the federal law presents a scheme that is so different from the state law that if you complied with the federal law, you'd violate the state law, and if you complied with the state law, you'd violate the federal law, okay? And so the example I gave you here is a fake example, but it's one, you know, when you fill up at the gas pump, you now know that you see that little sticker there that says this gas contains 10% ethanol, right? Mm-hmm. That's largely because of federal law on the area. So let's say that the federal law says gasoline cannot contain more than 10% ethanol. Well, gee, you go to a state like Iowa, which is a big corn producer, and all of our ethanol that is used in gasoline comes from corn. And Iowa wants to, you know, prop up the corn industry, wants a healthy corn industry. So what does it say? Not less than 12% ethanol. Everyone who sells gas in Iowa has to have at least 12% ethanol content in the gasoline. If you can't go over 10% to satisfy the federal law, and you can't go under 12% to satisfy the Iowa law, you've got impossibility preemption. You guys see that?
Mm-hmm.
It's impossible to comply with both, okay? And then finally, this takes us to obstacle preemption. And again, once again, you don't have express preemption. You don't have field preemption. The implied preemptions are field preemption and conflict preemption. You don't have field preemption. And you don't have now we'll look at conflict preemption. You don't have impossibility preemption. It's still possible to have preemption if the state law frustrates or presents an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. And I mentioned an old immigration case, Hines versus Davidowitz. We're going to look at a newer case today, the Arizona case that came down much more recently. But both of those cases are essentially obstacle preemption cases. And the reason for that is somewhat simple. The reason for that is that, number one, Article 1, Section 8 gives the immigration power to Congress, essentially. Number two, you can't have 51 different immigration laws and expect to have a cohesive immigration policy. To some degree, immigration policy is part of the fabric of our foreign policy. And so just think what it's like to speak to, you know, other countries from whom immigrants come and try to speak to them with 51 different policies of what they have to do to get into the United States. You can't have it depending on whether it's the Canadian border, the Mexican border, you know, or through some other method like flying in on an airplane type thing, okay? So, so that's it. Number one is express preemption. Congress, you know, expressly states in clear words that it expects this statute to preempt all conflicting state laws that deal with the same subject. That's number one. If there's none, then you look at field preemption. Is the scheme so extensive that Congress must have intended to occupy the entire field and leave no room for regulations by the states? And if you don't find that, you go on to conflict preemption. Impossibility preemption is it literally impossible to comply with both the federal law and the state law? If it is, you have impossibility preemption. And the reason you don't see this that often is because, you know, the lawmakers in the states aren't stupid. If there's an existing federal law here, they're not going to write it to conflict directly with the federal law. And then finally, there's obstacle preemption. Does the state law create an obstacle to the accomplishment and execution of the full powers, full purposes, and objectives of Congress? Okay, let's jump into these cases. We have Massachusetts involved in a lot of tobacco cases, and that's largely because this is an old reference that I meant to drop here. I'm going to cut that out right now. That's your last. That's your last version of the book, not the current one. So since the mid 1960s, the Surgeon General put out a report saying that smoking is hazardous to your health, and quite frankly, I don't know why, but it was surprising to a lot of people. And one of the reasons why it was surprising to a lot of people was because we have all these, look at this ad that I'm pointing at right here. Scientific evidence on the effects of smoking. I mean, literally, you would have Chesterfield running ads saying that smoking is good for you. You know, it'll keep away colds and things like that. And the other thing that cigarette advertising has done is used, you know, either the sexy woman, the objectified woman, like we have here on this one, obviously, or the Marlboro man, you know, the macho guy. They would try to suck up to a particular image. And they even tried to get kids, I don't know if you remember some of the later advertising, was Joe Camel cigarettes. They'd actually show an animal, a camel, you know, who was kind of this cool camel and said witty things and would hang out and smoke Camel cigarettes, essentially. And so after this happened, the federal government decided that it was going to require all the tobacco companies to put warnings on packages of cigarettes and in the way they were displayed. When I was a kid, you know, when I was a young kid in the 1960s and 1970s, there were cigarette ads on TV all the time. I haven't seen an ad on the TV in decades. And the reason for that is they were banned under this federal.
Can't hear you. Is it mine?
Yeah, it's you. Anyone else have a problem? Anyone else have a problem?
No, Professor.
I'm speaking nice, Karen. I'm speaking really loud, as I always do. So I think it's probably your internet connection.
Yeah, I just said it was. Sorry. Okay, thank you.
No, that's okay. LSMFT. Like you strike, mighty fine tobacco. There you go. I mean, there was back in the 60s and 70s, there was the women's liberation movement, which we, you know, now just call basic civil rights. But back then, it would, you know, it had to be given a fancy name. And they did Virginia Slims ads where they would show these independent women who were doing, you know, things like working as lawyers or being, you know, playing tennis or whatever. And they'd always have a Virginia Slim cigarette in their hand. So you know, in here are the various, you know, over the years, the various types of warning labels that were put on cigarettes. So, in any event, we'll go forward here. A whole bunch of states, with Massachusetts in the lead, whole bunch of states sued all the tobacco companies for, you know, between all the states, billions and billions of dollars. And the reason, what the states claimed was that people who smoked would end up getting sick and the state would end up paying for their health care, for a good chunk of their health care. And so it was, you know, draining the state treasury. And the cigarette companies who lured people into smoking by false advertisements and the like, by, you know, it went even way beyond that. I mean, literally hiding the scientific evidence of addiction, hiding the effects that they had known about for years. And so Massachusetts was one of the states with 45 other states. They all entered into these negotiations that went on and on and on. The Attorney General at this time was Scott Harshbarger, who was very anti-smoking. He was a you know, a big proponent of not smoking. And Harshbarger finally says, well, okay, we're going to settle. And the deal was that Massachusetts was going to get $7.6 billion over the course of 25 years. And what Harshbarger decided to do was to take the settlement. It's a lot of money. It can help help the state, but find a way for him personally to create these consumer protection laws that protect residents of Massachusetts from smoking, okay? So I've mentioned already Chapter 93A in Massachusetts, the Consumer Protection Act in Massachusetts. Whether you take consumer protection law or not, if you're going to be doing any practicing in Massachusetts, you will come across Chapter 93A someday. Chapter 93A, Section 2, authorizes the Attorney General to promulgate rules and regulations that are meant to, enforce Chapter 93A and to implement it. And over the years, the Attorney Generals have done just this. If you go to the Code of Mass Regulations, you'll find the consumer protection regulations that were promulgated by the Attorney General. So what Harshbarger did here was he used this power under Chapter 93A, Section 2, to create all these rules regarding advertising and display of tobacco products, okay? First thing we have here is that no advertising within 1,000 feet of elementary or secondary schools, public playgrounds, public parks with a playground. With one exception, you can put up a tombstone sign, the skull and bones tombstone type sign that says tobacco products sold here. So come in your own risk, so to speak. 1,000 feet, take the perimeter of a school ground, and radiate out 1,000 feet on all sides from it, and you're tearing up a whole bunch of the town or city or municipality between the schools, the playgrounds, and the public parks where this kind of advertising can occur. So if there's a convenient mart across from the street, obviously it would, across the street from the school, obviously it would be within 1,000 feet, okay? Regulations required warning labels on cigar packaging. And here's the big one: placement of all in-store tobacco advertising at least 5 feet high. So in other words, so that kids wouldn't come in and have it right in their line of vision to see the advertising. And so he set up these regulations. They were going to go into effect, and before they do, a couple of things happened. Number one is that Lorillard and other tobacco companies, Philip Morris, I can't remember the name of all of them, all decide to sue, essentially, to prevent the enforcement of this. And then the second thing that happened was that Scott Harshbarger ran for governor and lost and was no longer the Attorney General, and he was replaced by a guy named Tom Riley. So obviously the case became Lorillard versus Riley rather than Lorillard versus Harshbarger, because Riley was obviously the chief law enforcement officer. The Attorney General is the chief law enforcement officer, plus the office that created these regulations. So the claim here is preemption. They say that there's this scheme that Congress has, and it expressly preempts. Here's what we say here, and expressly preempts where's my well, I was looking for the language of the cigarette advertising stuff, but I'm not having any luck. So it expressly preempts any state laws that have to deal with cigarette advertising. and you know, whatever the medium is, so to speak. And so the Attorney General says kind of the same argument in the main case that we just talked about. The Attorney General says, well, wait a second. These regulations are consumer protection regulations, protecting people from being deceived by the tobacco companies. They are not based on smoking and health. No health-related contact. They instead target youth exposure to cigarette advertising. Justice Sandra Day O'Connor wrote the decision, and she said, "Come on, this is about health. The problem here is that you're using deception to essentially create these regulations that try to ameliorate the bad health effects of tobacco, and Congress has already done that." Okay, she says essentially, look, Congress has made it clear they wanted to create a uniform approach, one that was the same across the entire nation, and we can't allow all the states to be going forward and coming up with their own laws that would frustrate this sort of uniform approach. Interestingly, the only measure that survived was the cigar measure, the cigar labeling measure, because the federal law only dealt with cigarettes. It didn't deal with cigars or smokeless tobacco. My understanding is that smokeless tobacco has now been regulated in the time since. Anyone here ever do a dip or a chaw before? I have a son who played. Do you want to add to that, Teddy, or are you just acknowledging? I have a son who played college baseball, and thank God he wasn't one of the guys who dipped. But a bunch of the kids, when they get to college, or even if they don't go to college, it's the thing to do in baseball for whatever reason. A lot of his friends actually became pretty much addicted to it. I mean, it still has nicotine in it. And his coach was, as soon as we get on the bus after a game, he put a big jar in his mouth. You weren't allowed to you can't have alcohol and tobacco products on NCAA fields unless it's a Division I sport under certain circumstances. So none of them could dip while they were playing, but a lot of them developed it, huh? You know, this would have been, vaping wasn't a big thing back then. So people would not be vaping. So
Professor.
Yeah.
I used to work for the Commonwealth starting in '95, and we gave out grants for, not only we did the DARE program, but we did for anti-smoking campaigns for schools. So
Yeah.
a lot of that money, that $7.6 billion, I don't know if it's how it's being allocated today, but it was used for educational purposes, I guess.
You got to spend some of it, huh?
Yeah.
That's a nice thing. So settlements are always good. Even when you're fighting the devil, you get so much more surety out of settling a case than litigating it. You know, it's the bird in the hand is sometimes worth two in the bush, right?
Mm-hmm.
So and hopefully that money, it sounds like then that a lot of that money was put to good use, which is a good thing. I'll tell you what, I'll just wander for a quick second here. Tobacco and alcohol. The public school health departments deal with that stuff so well these days. Unlike in my days, my generation, we all knew some teenage kid who was killed in an auto accident that involved drinking and driving. And my kids and their friends always I'm not saying that they were perfect and didn't drink before they were of age. Most kids do to some degree, but they were always really good about using designated drivers. And I think they sort of learned that through education. And the same with smoking. They learned fairly early on how bad it is for you. And I think what's helped, you know, so many fewer smokers today than in the old days. You can't smoke in restaurants and bars anymore. And it wasn't that long ago that you could. So I think most of that, some of it's been through regulations, but a lot of it's been through education. And I suspect that, you know, some of the education is programs with money that has flowed from the state through these types of settlements. So, okay. Let's get on to implied regulation, implied preemption here. Florida lime and avocado growers versus Paul. California, and by the way, I'm going to suggest to you once again, gee, what a surprise. I'm going to suggest to you once again that these cases are not going to be entirely consistent with each other, okay? And the same is going to be true when we get to the Dormant Commerce Clause as well. So much of it has to do with the makeup of the court. You know, how many of the justices are liberal, how many of the justices are conservative, so to speak. And so you see sort of differing approaches to all of this stuff. So California, you know, states, we're going to see later on when we do Dormant Commerce Clause, states are obviously known for certain things, right? Idaho is potatoes, Maine is potatoes. California, obviously avocados to a large degree. Washington State is known for their apples, apparently. And so then what the states try to do is try to, you know, protect their own, protect not just their own produce, but also the growers of the produce and all the other industries that are involved with it. So California thinks that its avocados are pretty good. And so it creates these sort of grading standards for the avocados and says essentially that no avocado shall be sold in California unless it contains at least 8% oil by weight. And I guess avocados, you know, have good oil in them, but, you know, I think an avocado is probably about the most caloric fruit that one can have. So they put this out, and the Secretary of the Agriculture has a wholly different grading standard. The USDA has a wholly different grading standard, has nothing to do with oil content. So apparently Florida avocados are skinnier avocados than California avocados. They don't have as much oil in them. And so the Florida growers who wanted people in California to buy their avocados, and I don't care what state you're from, you'd want them to be made available in California. What does California have? 30 million people or something like that? I think it is by far the most populous state in the country. You certainly want to have an inroad into that market, and all of a sudden, because their avocados just don't come up to 8%, they can't. They argue. A couple of things here, but we'll only look at the first of these. Is that the federal law that graded on grounds other than oil content preempted the California law. We'll see later on that the equal protection claim is crap. And you know why already, right? Let's go back to 11th Amendment. When can we use the third exception to 11th Amendment immunity? Race, national origin, alienage, gender, fundamental rights. Economics are guided by rational basis, not one of the enhanced scrutinies, which means that if you're claiming that I was economically discriminated against, then all California has to issue is a rational justification, which it certainly can. And then the third one we'll talk about later on, and we're going to have similar cases to this, is it interfered with their right to engage in interstate commerce. And what they're really claiming here is the dormant commerce clause, which we're about to start in a little while. But we're not going to talk about that right now, okay? Here, the California court held that there was no conflict with federal law. The federal law did not preempt it. Because there's no conflict, you don't have to worry about preemption at all. And it went through, first, there's no express preemption under the federal laws. Second, there's no field preemption here. And it's not an impossibility preemption because you can comply with both. Florida can have avocados that are 8% in oil and also comply with the federal standards. And then finally, there's not obstacle preemption because the California law did not frustrate the purpose of the federal law. The purpose of the federal law was really to regulate competition more than anything else. So the court here found that there was no preemption and California could still require its fatty avocados. Pacific Gas and Electric versus State Energy Resources, 1983. I think we've mentioned this issue with nuclear energy before. In the 60s, 70s, and into the 80s, at least the early 80s, a fair number of nuclear power plants were being built in the United States. European countries to this day are primarily, the electrical power generated is primarily through nuclear power plants, France, for example, and Japan as well in Asia. The big problem with nuclear power is that it produces waste. And it produces waste that's very dangerous waste. And it produces waste that stays around for eons and eons. It just doesn't disappear. And so, storing the waste, disposing of the waste, it became a big issue. And unfortunately, the country seemed to lack the political will to deal with how we were going to dispose of the waste. So California passes this law, the Warren-Alquist State Energy Resources Conservation and Development Act. It had two provisions that were claimed to have been preempted. The first one, the Energy Commission has the authority to require a person who's about to build a plant before being licensed to show that they're going to have adequate storage space for these spent fuel rods. And then the second provision placed a moratorium on the certification of new plants until the California Energy Commission can find that there's been developed and that the United States, through its authorized agency, has approved, and there exists a demonstrated technology or means for the disposal of high-level nuclear waste. So these are challenged: Pacific Gas and Electric, San Diego Gas. They claim that they are preempted from the Federal Atomic Energy Act. Justice Byron White wrote the opinion here, the majority opinion, and he does what you're supposed to do, which is examine the federal act and compare it to the state act and look at what the purposes of the federal act are and the like. And what he determined from reading the Atomic Energy Act is that essentially, it created a dual system of regulation over nuclear power plants. The federal government took charge of the safety issues, and the states took charge of the economic issues, okay? What he says here is that this law, whoops, here the provisions of this law are not really geared towards the safety issues as much as they are geared to the economic issues. And so he held that this, without express preemption, we don't have field preemption. Indeed, we'd have just the opposite. We have sort of a sharing of responsibilities under the Atomic Energy Act, number one. Number two, there's no impossibility preemption, and there's no frustration preemption when it comes to economics. Now, I'm not sure if you know, this case obviously predates the Riley case. I'm not sure that the Riley court would have taken the same approach, because what Justice O'Connor essentially says is, come on, all cigarette advertising, when you get down to it, bottom line, the regulations on cigarette advertising are about protecting health, not about preventing deception. It's about protecting health, because the deception is what leads to the health problem, right? And I think a similar argument could be made here for this. You say it's economics, but really what we're talking about is long-term storage of these very dangerous rods that are removed from nuclear power plants, okay? Arizona versus United States. This is our obstruction preemption case. It came down in 2012. This was written by Justice Anthony Kennedy, who has since retired from the Supreme Court. In this case illustrates a lot of the frustrations that so-called border states have with illegal immigration. So obviously, you know, California, Arizona, New Mexico, and Texas have their fair share of illegal immigration from the southern border. I don't think that illegal immigration is a big deal on the northern border. Up until fairly recently, we just used to go to Canada to get a cup of coffee. Has anyone ever been to Niagara Falls? My wife and I were staying there on the American side. We decided we wanted to go to dinner on the Canadian side, literally drove over the bridge, went through customs. It took 2 seconds. They asked, where are you going? We said, to dinner. We had dinner, we turned around and came right back. Not a big deal.
Very nice there, yeah.
What's that?
Yeah, I've been there. It's very nice.
Yeah, exactly. It's beautiful. So, you know, now you need a passport to get into Canada, but getting a passport is no big deal. So, you know, whatever. So in any event, Arizona enacts this law in an attempt to suppress illegal immigration. And what the Arizona politicians would tell you is that they're just frustrated that the feds aren't doing enough to prevent it. And the border states are the states that are dealing with the problem more than anyone else. So we should be able to pass it. And it goes on and it enacts this law, makes it a state crime for anyone to be unlawfully present in the United States without registering with the federal government. Makes it a misdemeanor to seek work when you're not a legal immigrant. Requires, in some circumstances, police officers, when they stop or detain someone, to verify the citizenship or alien status of whomever they've stopped. And Section 6 authorizes arrests of aliens believed to be removable on the United States if there is probable cause, without obtaining a warrant to do so. Kennedy struck down just about all of these, left one intact, and kind of had to do mental gymnastics to keep one of these intact. What he really is speaking of here is the very last one we looked at. The second part of conflict preemption, which is obstacle preemption. And, you know, he speaks about, he starts out by saying, the government's authority to regulate immigration and aliens is broad and undoubted. The national government has the power to establish a uniform rule of naturalization. It's right in the Constitution. We need to have a uniform system. We need to speak in one voice. And having different states have these different laws are essentially frustrating the purpose of the federal immigration system. Okay. Let's look at three. Let's look at three multiple choice questions here. Question, Teddy? Okay, did you unmute yourself? That's okay.
My question was like, for that particular case, there are some states and places that are calling for like sanctuary cities, kind of like places where they will not arrest illegal immigrants.
Yeah.
Is that kind of fall into that with preemption? Because the states are making their own rules on what the federal government's rule on. Would that preempt it? Kind of like going in the opposite way, what this case went.
Well, just the opposite. I think what the states or cities would tell you
Okay.
is that, well, I can tell you both sides of the argument on the sanctuary city cases.
Okay.
It's kind of a, as these things go, ideas often get co-opted by people who would never have been associated with them in the first place, I guess. The first idea of a sanctuary city was actually done by urban police officers, because what they were finding was that when they would round up illegal aliens for questioning, that they were so afraid of being deported that they wouldn't give any information involving crimes. So, you know, a crime would happen in a neighborhood, they come into the neighborhood, what did you see? What did you see? Nothing, nothing, because they don't want to be identified by their names and potentially get, and then that turned into a political movement that, you know, now has been associated with sort of liberal city mayors, I guess, is you know, the stereotype is that's the person who would do that. But think about that. We've already done our anti-commandeering cases, haven't we? In the anti-commandeering cases, I'll say, the federal government cannot commandeer state officials to do federal work for it. And so, you know, the biggest defense of a sanctuary city legally is that we're just maintaining our sovereignty from the federal government. We're not getting in the way of ICE agents or, you know, other immigration officers who are trying to round up aliens. We're just not going to help them do that. And we have the right to do that because we're a sovereign state and you can't commandeer our officials. Now, there was an incident in the news, what, 2 or 3 years ago? The judge in the, was it the Newton District Court?
Oh, yeah, I remember that case.
Yeah,
And
who
she
had,
allowed him to go through the back door or something?
yeah, there was apparently someone had been arraigned on a low-level crime, was going to be released on personal recognizance, but an ICE agent appeared at the courthouse and said that they were here to pick up this person on a, you know, I don't know the lingo of immigration law. I haven't practiced it, but essentially a deportable person. The judge said, well, wait out in the front lobby. And then she and a court clerk and well, she didn't herself, but she sort of orchestrated it. And the court officer, you know, pulled him out through the back door and he got away. And she's been charged with federal offenses. I don't know what exactly, obstruction of justice or something like that. She would have been totally within her rights, saying to the ICE agent, this is a state courthouse. You are not going to be making any arrests in my courthouse. Please go outside and leave. She certainly had the authority to do that. Instead, I think why she's in trouble is she tricked the ICE agent into thinking that the guy would come walking out the main way and he'd be waiting there to get him. And of course, you know, he had been rushed out the back door, so to speak. So, you know, these are interesting federalism issues that continue to exist. So, you know, there can't be, so in my mind, so let's think about our preemption analysis, right? In my mind, there can't be an argument that a sanctuary city is preempted by the federal immigration rules for one purpose. There's no authority of Congress to enact laws that force cities to cooperate and help federal officials. Nor could there be, would be lacking in authority, would certainly violate the 10th Amendment, which reserves police powers to the state, okay? So, yeah, no, and like so many arguments, you know, the original purpose of it, I mean, like, people don't know this, the Affordable Care Act was created by the Heritage Foundation, which is a conservative think tank. It was created as an alternative to universal health, single-payer health system, because conservatives are generally against that. And you know, now isn't it funny? Isn't it ironic how sometimes these ideas that come up are created by one side, all of a sudden are associated with the exact opposite side. And that's just natural with ideas in life. They take on a culture and a meaning that was never intended in the first place. Okay. In 1998, Congress passed a law authorizing the president to use his discretion in imposing economic sanctions on the country of Burma, which, by the way, is now called Myanmar, isn't it? The hope was the president would take measured responses to assure a transition to democracy. Congress stopped short of authorizing the president to prohibit U.S. companies from doing business with Burma. In 1998, the Commonwealth of Massachusetts also enacted the Massachusetts Burma Act, which restricted state entities from buying goods or services from companies doing business with Burma. A nonprofit advocate group for American companies that do business abroad sued the Massachusetts Secretary of Administration and Finance and other state officials, claiming that the Massachusetts law was preempted by the Federal Burma Act, infringes on the federal foreign power, and violates the Foreign Commerce Clause. In that action, A, Massachusetts will prevail because the nonprofit advocacy group did not have standing to bring the action on behalf of American companies that comprised its membership. Remember, we have organizational standing, right? And if some of these companies are members of this association, which must be the case because the association brought it, and the lawsuit relates to the purpose of the organization, promoting the trade of these people, and the individuals themselves, the companies themselves could have brought the case, there'd be organizational standing to bring the case, so that would be wrong. B, Massachusetts will prevail because it did not negotiate directly with the country of Burma. That's gibberish. I don't know what that even means, why that's even important. D, the advocacy group will prevail because it was literally impossible for American companies to comply with both the Federal Burma Act and the Massachusetts Burma Act. I don't think that's the case. The federal government did not prohibit companies, nor from doing business with Burma, nor did it force companies to do business with Burma. So it's not literally impossible, and that's wrong. Gee, I hope D looks better than the rest. D, the advocacy group will prevail because the Massachusetts Burma Act posed an obstacle to Congress's legislative aims. There's your best answer. It would be obstacle preemption, one of the two under conflict preemption. Look, whenever states start to get involved in federal law, there's gonna be preemption. I'm gonna tell you that, not federal law, foreign affairs. There's gonna be preemption. It's always the purpose of federal law that deals with foreign affairs to speak in one voice for the country. And whenever you have these individual states passing laws, it's going to frustrate the ability of the country to speak in one voice. This is a fairly easy one. A state recently enacted, by the way, I wrote that question. That was I don't know where I found out about this situation. It's a real situation that happened, and there was a Massachusetts Burma Act. And I might have changed the facts a little to suit my purposes, but that's not an officially released question. That's one that I created. Next one, a state recently enacted a law that denied unemployment benefits to former employees of both private and public employers who filed an unfair labor practice charge against their employers with the National Labor Relations Board. This is an interesting one, right? Is a state passes a law that says if you claim to have that your employer violated the NLRA, the National Labor Relations Act, and you file a claim with the NLRB, the National Labor Relations Board, you don't get unemployment compensation. Okay, the fact pattern goes on to explain what the NLRA tries to do. Two basic rights. Number one, the right to form, join, and assist a union. Number two, the right to engage in concerted activities for mutual aid or protection, which is an effort by two or more employees to improve pay, benefits, or working conditions. The NLRA provides administrative and judicial remedies for violations of employees' rights. Nothing in the NLRA expressly preempted state laws similar to the one enacted by the state. An employee who claims he was wrongfully discharged for exercising collective bargaining rights challenged the state law under an assertion that the NLRA preempted it. Based on the facts stated above, what is the most likely result in that lawsuit? A, the employer will prevail because the provision of unemployment benefits by a state is a matter outside the purview of Congress's commerce power and within the state's reserve power to regulate matters involving health, safety, welfare, and the economic benefit of state residents. What is it? San Antonio versus Garcia tells us that that's not the case. The Congress had the commerce power to regulate minimum wages, and it applied even to state government employees. So that's not right. B, the employer will prevail because the NLRA is silent about the state's ability to enact such legislation. Well, that would be correct if there was only one form of preemption, which is express preemption. And by the way, some people think that there should only be one form of preemption, express preemption. People who want to take, a very narrow view of what preemption should cover would in fact say that. But that's not what the law is, okay? As we know, there are two forms of implied preemption. One is field preemption, the other is conflict preemption. And conflict preemption has two subcategories, which are impossibility preemption and obstacle preemption. C, the employee will prevail because the state law at issue frustrates the purpose of the NLRA. That looks like a pretty good answer, because it does seem to. If you're going to punish someone for raising an unfair labor practice claim, in a proper forum that's provided under federal law, punishing them by saying they don't get their unemployment benefits would seem to frustrate the purpose of the National Labor Relations Act, the way that the facts set it out up there. D, the employee will prevail because it is literally impossible for an employer to comply with both the state law and the federal NLRA. Well, no, it really isn't, because the employee didn't need to file a claim, I guess. C is certainly a much better answer. So C is your correct answer on that one. Then I have one more. This is that state tort action based on the common law that I was mentioning before. And I'm calling your attention to this because what students tend to do, I start out by saying you have to have both a federal law and a state law. And so what do the students think when they think state law? They think legislation. And that's all they think, legislation. They forget entirely about state common law as well. State common law has not been enacted by a legislature. It's judge-made law. It comes up during litigation and appeals of litigation. That's where the law is made, okay? So here we have a federal law. And railroads are very highly regulated. Federal law has specified automatic gates and flashing lights at railroad intersections. The law provides for funding for construction of such devices, and it has the following provision. Laws, regulations, and orders related to railroad safety shall be nationally uniform to the extent practicable. A state may not adopt or continue in force a law, regulation, or order related to railroad safety that fails to conform to the regulations or orders promulgated or issued by the Secretary of Transportation. So a plaintiff's husband was killed at a railroad crossing, hit by a train, and the crossing had installed one of these federally compliant automatic gates and flashing lights. The plaintiff brought a wrongful death action. This would be under state tort law, right? In the federal court against a private railroad obligated to maintain the crossing, alleging the railroad failed to install an adequate warning device at the crossing. There's the whole nub of the question. They're not claiming it was improperly maintained. They're saying they failed to install an adequate warning device, okay? The railroad defendant has moved for summary judgment, arguing the federal statute bars the wrongful death claim. On that motion, the trial court should A, deny the motion because the state's police power to protect its citizens from unsafe conditions is guaranteed by the 10th Amendment. That is correct, but there's overlap sometimes, as we've seen in the civil rights cases. You know, the Katzenbach case and the Heart of Atlanta case, for example, case. And also in regard to working conditions case, like in the last question, the NLRA, there is going to be overlap. And when there is overlap, when there's commerce authority that Congress has, when there's overlap, which law yields, the federal law or the state law?
Federal.
The state law yields. The federal law preempts the state law, okay? B, deny the motion.
What was that when there's what? The federal preempts the state?
Just what we've been talking about the whole class. It's called the supremacy clause.
Oh, okay, gotcha.
When federal law conflicts with state law, which law yields? The state law. Federal law preempts state law when there's a conflict. B, deny the motion because denying the plaintiff her common law tort claim simply because Congress has the power to legislate in a given area would deprive her of due process. That's a pile of poo. It basically says nothing. It doesn't even tell you how it violates due process or anything of the like. Plus, we haven't even talked about the due process clause yet. So that's wrong for a number of reasons. C, allow the motion because Congress's power to regulate channels and instrumentalities of commerce is plenary. Plenary means absolute. No. While Congress does have the absolute power to regulate interstate commerce, sometimes that overlaps with the state's authority under its police power. So you can't say that Congress is the only one who gets to regulate here. D, allow the motion because the statute expressly preempts state common law claims. That is about as clear a statement of express preemption as you are going to see. That was a fairly vivid description. And, you know, it says nationally uniform to the extent practicable. No state may enforce a law, regulation, or other order related to railroad safety that fails to conform to regulations or orders promulgated by the Secretary of Transportation. And the facts tell you all over the place that this is an approved crossing device. So D is your best answer. Okay. All right. Let's start the dormant commerce clause in the time that we have left. So, you know, again, um, we're talking now about limiting state power. And the first way that we're dealing with this is have Congress directly limiting state power through preemption, right? Congress passes a law that intrudes a little bit into state law, but because the law is authorized under the Commerce Clause or Section 5 of the 14th Amendment or whatever, the Supremacy Clause says that the state law must bow to the federal law preempts. Now we're going to be talking about Congress not doing a damn thing. Congress not legislating at all, but somehow is magically exercising this power through the so-called dormant Commerce Clause. It's kind of like the Commerce Clause asleep, still is active, essentially. Justice Thomas doesn't call it the dormant Commerce Clause. He calls it the negative Commerce Clause. And by the way, he doesn't believe in it because he can't find it in the Constitution. Okay. I'm not saying that as a criticism. I'm just saying when you read the dissents and you see his dissent, that's what he says. It is judicially created, so it's obviously not expressly stated in the Constitution, and it's an interpretation of the commerce power that prohibits a state from passing legislation that improperly burdens or discriminates against interstate commerce. So it is self-executing. It applies even when Congress has not acted in the area. And you know, this last point here is sort of the main one that you're going to be looking at. Most of these cases are going to involve just this: prevent the states from discriminating against out-of-state businesses or from giving in-state businesses an improper advantage in the marketplace. Okay. Now, this is going to be important because we're going to be looking at the Privileges and Immunities Clause of Article 4 after we're done with the Dormant Commerce Clause. That'll be on Thursday. And what we're going to see under the Privileges and Immunities Clause is that it only protects citizens of the United States. Think of citizens as in people who have the right to vote. Is a corporation a citizen of the United States? Has anyone seen a corporation at their local voting hall in recent times? No, obviously not. So we're going to see that the Privileges and Immunities Clause under Article 4 does not protect corporations. It only protects human beings who are citizens. Not only does it not protect corporations, it doesn't protect lawful or unlawful aliens because they are not citizens of the United States. So even people who are here on permanent resident status, you know, proper permanent resident status, will not be able to use the Privileges and Immunities Clause of Article 4. Now, why the hell am I talking about that when we're not doing that until Thursday? Because it looks an awful lot like the Dormant Commerce Clause, and it is very different from the Dormant Commerce Clause in this regard. You don't have to be a citizen to enforce the Dormant Commerce Clause. So corporations and aliens are allowed to enforce the Dormant Commerce Clause. They're allowed to claim that the state is discriminating against them in their businesses, okay? So that's why I have this last paragraph here. The Dormant Commerce Clause works both for individuals and corporations who claim discrimination. One does not have to be a citizen of the United States to make out a Dormant Commerce Clause case. I'm just going to tell you a general thing to sort of bear in mind. All of the protections under the Constitution are generally available to everyone who is either a citizen in the United States or is in the United States, physically present in the United States. The Privileges and Immunities Clause is an exception to this. It requires that you be a citizen of the United States, not just a legal resident. You know, won't protect you if you're a legal resident. The Privileges and Immunities Clause won't protect you if you're a corporation, okay? All right, so I think we'll have a chance for me to run through the methodology right now before we finish up. We might be able to get a case in. This methodology is not going to mean anything to you until we start going through the cases. But I want to get it down, and then at the beginning of the next class, we'll do a quick review of the methodology again, just so you have it at the top of your mind, and then we'll go through the cases, okay? So number one, there has to be a state statute or law. There will not be a federal law in question. There will only be a state law in question, okay? If there is both a federal law and a state law, you're going to be thinking about preemption. If there is only a federal law, you're going to be thinking about a straight application of the Commerce Clause, not the Dormant Commerce Clause. With the Dormant Commerce Clause, and again, this first slide is really to help you spot the issue, okay? With the Dormant Commerce Clause, there's going to be there's going to be only a state law. And it's going to be claimed that the state law discriminates against out-of-staters. Everyone have that? Number two, you have to make a determination of whether the statute facially discriminates, whether on its face it favors in-staters over out-of-staters or otherwise discriminates against out-of-staters, okay? Now let me give you an example of one that facially discriminates. If I want to go to a state university in Massachusetts and I live in New Hampshire, am I going to pay the same as a resident of Massachusetts?
Nope.
I'm going to pay a significantly higher tuition than someone who lives in Massachusetts. And this is true with virtually all the state schools. That is a facial discrimination against out-of-staters, okay? Now we're going to see that the only reason that states are allowed to do this, and there's no violation of the Commerce Clause, of the Dormant Commerce Clause, is because it falls within one of the exceptions to the Dormant Commerce Clause, the so-called market participant exception, okay? But for that exception, that is a clear facial discrimination. You're treating out-of-staters worse than in-staters. You know what one of the biggest complaints about the Massachusetts state college system is these days? Is that they take too many out-of-staters and it's really hard for in-staters to get in. And why do they take so many out-of-staters?
More money.
They get more money. They make more money, right? You know why colleges love foreign students? Not only do they get the even if it's a private college, foreign students are not getting financial aid. They're paying full ticket, right? So schools have to look at their budgets. So okay. So does it facially discriminate? If it does, it's almost certainly going to violate the Dormant Commerce Clause. Now we're going to talk about lawyers are the most uncreative people in the world, okay? Because we're going to be talking about strict scrutiny and intermediate scrutiny. We're going to use the same phrase, and it's going to mean different things at different times. So we're going to talk about strict scrutiny right now, with the Dormant Commerce Clause. We're also going to be talking about it with the Equal Protection Clause in the fundamental rights situation under substantive due process. But then we're also going to be talking about it in regard to free speech. And there are slightly different meanings each time we talk about it. The definitions are a little bit different, okay? So I'm just warning you about that. It's not fair. Why don't we just come up with different names? so that you know right off the bat which one we're talking about, okay? This is the strict scrutiny test. Can the state show that it has no other means of advancing a legitimate local purpose? No other means of advancing a legitimate local purpose. This isn't impossible, but it's a near impossibility for a state to do. So under the strict scrutiny test, if there's a facial discrimination, almost always the plaintiff is going to win. The state is going to lose. Even if it doesn't facially discriminate, it still might have a discriminatory effect on interstate commerce. If it has a substantial discriminatory effect on interstate commerce, rather than a mere incidental effect on interstate commerce, we still use strict scrutiny. This gets kind of mushy and murky, so just bear with me. So even if it doesn't facially discriminate, you have to ask yourself the following question. Okay, but does it have a substantial discriminatory effect? Even if it's not true on the face, is there a substantial discriminatory effect? Or is it just an incidental one? If it's substantial, then we treat it exactly the same as if it's facial discrimination. We use this strict scrutiny test that I just mentioned, okay? If it is not facially discriminatory and has only incidental effects on interstate commerce, we're going to apply, we'll look at this case on Thursday, Pike versus Bruce Church, call it the Pike balancing test. This is a really vague test that is tailored to suit the purpose of whichever judge is writing the decision. Balance the local benefits derived from the law against the burden it creates on interstate commerce, okay? Now, liberal justices who like strong federal government are usually going to find that it discriminates. Conservative justices who like strong state governments are usually going to find that under the Pike balancing test, that the local benefits outweigh the effects on interstate commerce, okay? So, again, it comes down to whatever your vision of how federalism should work is. It's going to come down to that. So in Pike, you consider the nature of the local interest involved, whether it could be promoted with lesser impact on interstate activities. Usually the justification that the state or the municipality is going to have to raise is going to have to be a police power one, health, safety, welfare, and the like, okay? If you find a dormant Commerce Clause violation, check to see whether one of these two exceptions applies. I will tell you that the first exception applies a lot more frequently on the bar exam than the second exception. Number one, the market participant exception, or A, I have it here. If the state is acting more like a business or a customer rather than a market regulator, then it is allowed to discriminate. So White versus Massachusetts Council of Construction Employers, the city of Boston had a residency requirement for a certain percentage of contractors. It was claimed that this violated the Dormant Commerce Clause because contractors from out of state couldn't work. The city of Boston hired these contractors to work on city-owned projects. So the city was building its own buildings, was acting more like a business than as a market regulator. So therefore, it fell within this market participant exception, okay? And again, I gave you another example already. UMass charges higher tuitions to out-of-state students. UMass is in the business of running a college. The state is in the business of running a university system. It is acting more as a business than as a market regulator, okay? Number two is that sometimes Congress approves of local discrimination, actually passes a law that allows a state to discriminate in interstate commerce. Usually it's sort of a makeup thing, you know, to allow states to deal with I don't know, predatory practices that have been involved, that they've incurred themselves. And we'll look at later on the Western and Southern Life Insurance Company versus State Board of Equalization of California, where out-of-staters Congress allows California to charge higher taxes on non-California insurance companies than California insurance companies. Okay?
Hi, Professor.
Yep, who's that?
This is Eunice. Now,
Right, Eunice?
what would the toll come under where they charge different toll for in-state residents versus out-of-state residents?
Well, the same thing is the state is acting more like a business. It is running a state highway system and it is charging tolls for the highway system. So it'd be the market participant exception, Eunice.
Hmm.
And those cases have come up. They have come up. I don't think many states do that anymore, but when we first got our transponders, I know that, you know, Massachusetts would charge less to Massachusetts residents and New Hampshire would charge less to New Hampshire residents. I think they've pretty much equalized now, but those cases came out under the market participant exception. And I think if you go back and you look at my old exams, I think you'll actually find a question on that with a model answer on that, Eunice.
Okay, thank you.
Yeah, I have them all the way back to like, I don't know.
2005, I thought.
There's a lot. It's very overwhelming though, how to focus. So I'm getting like, I don't know, I have to just make a better outline, I think.
I'm an overwhelming kind of guy, Karen. That's,
No, it's just,
it's the nature of the beast, I think.
it just seems like it's getting more, you know, complicated. I had a better handle in it like 2 weeks ago, but I don't know. Well, it's because I'm doing. so
It
much-
is. There's a lot here. Wait until you hit real property.
Hardly wait. Can hardly wait.
Yeah. Why do they have Malaguti teaching the two subjects the students tend to find the hardest? Although contracts is very hard as well.
I did okay in contracts though, but are people getting like 5s on the quizzes? Is that like curve, or I mean, do you want to just?
I think everyone but you, Karen, is getting
Yeah.
5s.
Is it varied? I mean, is it varied?
Yeah, of course it is. I've told you already, the quizzes are not going to hurt you because remember, there's going to be a scale, and hard questions are hard questions that students don't tend to get correct, and easy questions are easy questions that students tend to get correct. And if you think about it, so you got a 4 on this one and your friend got a 3, well, that puts you 1 point ahead. On the next one, they get the 4 and you get the 3, and all of a sudden you're even again. So, you know, at the end of the day, those things tend to equal out quite a bit.
Okay.
So I wouldn't, you know, I'd use the quizzes for what they're intended, which is to number one, force you to focus every week and stay up with the material. And you're right, it does become a pile of mush in the head because it's all new and it's all hitting you all at once, it seems. And what you'll find is, and look, I'm not saying anything new. You guys have gone through your first year already. What you find is that with targeted studying at the end, that pile of mush will start to attain at least some clarity.
Yeah, no,
And
what I'm
it's
saying-
lost, so no one gets full clarity. So
no, what I'm saying is the quizzes aren't bad, but they're weekly, they go by each topic each week. So you know you
Yeah.
might not ask something like X when you're going to ask Y. That's my strategy on them. But when you come to the final, you've got to, they're all mushed together. So you just,
Yeah.
I'll do okay.
but
I'll
see,
do
the best way to learn is to compartmentalize and to have you focus just on the, you know, the one thing at a time.
okay.
Still hear the what? The Brooklyn Bridge rule in your sleep. Yes, Teddy is a survivor of real property, and he's saying the stupid Malagutiisms he still remembers.
Yeah. No, it's,
So yeah. All right, guys, I'm going to let you go. We've used up our time, so we'll start with these cases on Thursday. Okay.
Thank you. Bye.
Thanks.
Bye-bye.
Bye-bye.
Bye.
Really? I didn't know she knew the Brooklyn Bridge rule.